Good
Would you like a
afternoon.
moment to?
Good afternoon.
Would you like a moment before we proceed?
No, I'm good. I'm
Your
ready.
Honors, if we may reserve 5 minutes on rebuttal.
5 minutes, certainly.
May it please the court, my name is Cody Gallagher. I'm a member of the Nashville Bar, and I'm appearing on behalf of the appellant, Mr. Paul Eichel. Your Honors, this appeal concerns a premises liability and a negligence case stemming from a shooting that occurred in August of 2014. The complaint in this matter was filed on July 31st, 2015 in the Davidson County Circuit Court. Initially, the case was presided over by Judge Kelvin Jones until the end of August, or till the end of 2022, excuse me, and then Judge Ingram took the bench in or around January of 2023. So we really had two judges that oversaw the two matters that are being appealed in this case. Mr. Eichel is one of the named defendants, and he was sued on behalf of the appellee, Mr. Crutcher, and was named as the purported owner of the nightclub where Mr. Crutcher was injured. And of the three issues that we raise on the appeal, the first issue is pursuant to Rule 60, where our client asked or asserts that the trial court erred in denying the Rule 60 motion to set aside the default judgment that the court granted in June 2016. And the second issue our client raises is that the trial court erred in its award for damages, which we'll address in a moment, and that falls under Rule 52, Tennessee Rules of Civil Procedure. And the third issue is our client's request for attorney's fees and costs on appeal, which this court has well established and falls under Tennessee.
What authority is your client entitled to attorney's fees if he wins?
In support of that, he cites Tennessee Rule of Appellate Procedure 40A, Your Honor, and he follows the precedent that if the case is reversed in his favor, then the court would be inclined to grant him his fees. If it's,
I'm not aware of that.
It's cited in our brief, Your Honor.
Don't you need a statute or a contractual agreement to be
Well,
entitled to attorney's fees?
It does mention in the case and in the citation of our brief that in absence of a statute or a contract for an award for attorney's fees.
So Rule 40,
Tennessee Rule of Appellate Procedure 48, Your Honor.
48.
48, yes, Your Honor.
Okay, thank you.
Mm-hmm. And I'll start with the first issue. Our client asserts that the trial court erred in denying the Rule 60 motion to set aside. Mr. Eichel was served, and a default judgment was entered against him on June 30th, 2016, and he attached several declarations under penalty of perjury to his motion, his Rule 60 motion to set aside the default judgment, where he lists the multiple ailments and physical and medical issues that he dealt with over that time. And so according to our client...
Andy said he didn't own the nightclub.
Correct. We were going to get to that. Yes, Your Honor. That's really the second component, the second element. He attaches, just as Your Honor mentioned, corporate stock certificates dated March 21st, 2013. That's more than a year prior to the day of the shooting. And so what the plaintiff did was he named multiple defendants here, and he names the owners of the building itself, which there are multiple. And systematically over the course of the years between 2015 and 2022, those defendants are all removed. They're all dismissed, and they're all let go from the case. And then the actual owner, who our client asserts who owned the nightclub, Joe Savage, he passed away, so he's now deceased. And our client, as of today, is in the hospital, so he's not doing well. His cancer has returned, so he is, it's not looking good, and I won't get into those details. They're not on appeal today, and they're not before the court. But of the three issues, and I do believe that the issues and arguments in our brief are well versed, and I'm open to answering questions if that is a better use of the court's time.
Well, the motion to set aside the default judgment, the trial court considered it and denied it, and that's an abuse of discretion standard of review.
Correct, Your Honor.
So how did the trial court abuse its discretion?
Well, our argument, Your Honor, in denying the motion, and this was a ruling by Judge Kelvin Jones, so we filed the timely motion to set aside default judgment, which was denied, and then the motion for a rehearing or motion to reconsider was granted. And so there was not a robust ruling on the application of Rule 60. It was just summarily denied, so the court has denied your motion. And so we don't have a standard or any factors to review. This court is unable to look back and say, okay, this is a correct application of the law. We just know that the court denied it. We don't know what the judgment was based on or whether the rule was correctly applied or what factors it considered or what elements went into the court's decision. There is no rationale. And that's the genesis of the second component of our client's appeal too, is the damages order, which in itself is a 2-page order issued by the court and essentially grants $300,000.
Is the court required to do more?
Well, under Rule 5201, Your Honor.
Let me ask the
Oh,
question
sorry,
first.
Your Honor.
Is the court required to do more when it rules on that motion?
Which motion, Your Honor? The Rule 60?
Yes.
Well, that's a question that this court, I would say yes, because this court is not able to review or sufficiently discern whether or not an error was made when there is no rationale or when there's no basis for it to review the court's decision.
Can you point to a specific statute or rule that requires the court to do that?
Well, in the second prong of our appeal, so in the second issue.
No, on that issue.
No, Your Honor, I have not cited a specific case or a precedent that would apply to the Rule 60.
Okay, all right.
And that's being fully transparent with the court. Now, on the Rule 5201 issue, we do point to case law, and in the Lugo case, Lugo versus Lugo, it specifically says under Rule 5201 that this court cannot conduct a meaningful review of the trial court's award and amount unless it has given specifics, unless it's applied factors, and it cannot assume or speculate as to how a court reaches its decision. And that's really the genesis of the second issue that we raise on appeal, which is the award of $300,000 in non-economic damages.
Well, doesn't your client, in a motion to set aside default judgment, have to do 2 major things? One, give a justifiable reason why he didn't file an answer in responsive pleading in the period before the court, and then 2, even if the client can do that, they're supposed to show that they have a meritorious defense.
Correct, Your Honor.
And that's in the record?
It's in the record, and it's also in our brief, Your Honor. So when you mentioned whether or not it was willful, right? You say, was the neglect willful? Why didn't you file an answer? Why didn't you participate in these proceedings? Specifically why we list all of the medical ailments he went through. So he had open heart surgery, he had a heart attack, and he survived throat cancer. He was dealing with all those things in between the time 2016 and 2022 when this matter came to fruition and actually came on to be heard.
You don't think during those 6 years he could have called an attorney and say, I've been sued, would you mind filing a responsive pleading and tell him I'm sick or something?
And in response to that question, I think I can answer that by saying his position is he specifically contact plaintiff's attorney to tell him, I don't own the nightclub. I gave that to Joe Savage in 2013.
Well, that most plaintiff attorneys don't go away on a phone
I understand that, Your Honor, and I appreciate that, and I understand that. So I do not have a response to that, of course. And it would be frustrating if he was represented and he would not have acted on that advice of us as counsel either. So he was unrepresented at that time, and it was his assumption that the matter had been disposed of. And again, he was dealing with those medical issues over those years, so that took precedent. And as he mentioned, and is mentioned in the record on his declarations under penalty of perjury, he had to go to Florida to deal with a lot of those issues. So he's going through surgeries down in Florida and recovering from those. I think this was distant from his mind and the last thing that he was thinking about at the time, especially with his life on the line. And those 3 elements that the court mentions, I know my time is dwindling down, but I do want to mention there are meritorious defenses that our client posits, and he has asked that the court reverse and remand the case and that he be allowed to assert an answer and assert these affirmative defenses. Number 1, he wasn't the owner of the nightclub. So that questions the entire integrity of the plaintiff's claims for negligence, where he owed him a duty. If he's not the owner of the nightclub, that would defeat or negate an essential elements of the plaintiff's claims. Number 2, assumption of the risk, comparative fault issues, and if it did go to trial, if it did survive a summary judgment and it did go to trial, our client is certain, and he's certain that he would not be at least 51% at fault for the injuries to the plaintiff, or at the very least it would negate any recovery to the plaintiff. And lastly, a question of whether or not it was prejudicial in our client's position is more than 10 years have passed. This is nominal prejudice to the plaintiff, where our client has unfairly and inequitably been applied a $300,000 judgment against him, where he's claiming, I didn't own this property, I had no responsibility owed to the plaintiff, and frankly, based on all the facts and circumstances in this case, I did not owe him a duty and I did not breach that duty. Certainly not to justify a $300,000 judgment. And lastly, Your Honors, I would mention in the second issue raised on appeal, the order itself, the award for damages, is completely devoid of how the court quantified or arrived at the amount of its award. It just simply it awards $300,000 in non-economic damages with mention to the statute, but without application of the statute. It doesn't say, here's the factors the court considered, or here's how and why the court arrived at this amount. And because of that, under the Lugo case and under Rule 5201, this court cannot conduct a meaningful review of the court's award in the amount of $300,000. And for that reason, our client is asking that the court reverse and remand for further proceedings.
All right, thank you,
Thank
sir.
you, Your Honor.
We'll hear from you on rebuttal. Mr. Stover.
Good afternoon, Your Honor.
Good afternoon, sir.
May it please the court, my name is William Stover, and I represent the appellee and plaintiff in this case. This was a premises liability case involving an incident at a nightclub here in Nashville wherein Mr. Crutcher was shot 3 times. He suffered a serious injury in that incident. He filed this lawsuit against the club. And regarding this particular defendant, Mr. Eichel, he was the owner of the premises, of the nightclub itself, not the land, not the building, but he leased the building from the owners.
The Ellis is on the building.
Yes, yes, Your Honor. The Ellis, Johnny Ellis et al. It was a family organization, but they essentially jointly owned it and in a business venture leased it through a management company to Mr. Eichel, who originally leased that property under the name of Club Vida Loca, and subsequently changed it to the name that it was. I'm sorry, this case has been it changed its name, but he remained as the owner. And we obtained a default judgment against Mr. Eichel in 2016. There's no argument by Mr. Eichel that he did not receive the summons, that it was not served. There's no indication that he was unaware of this lawsuit, but instead, 6 years after the judgment was entered against him, he appears in court. He made an appearance in February in court prior to the damages hearing and still did not file a motion until the day before the damages hearing was to be heard in August of that year. So even arguing that, even assuming that there was some illness that prevented him from doing something prior to that after that 6 years had passed, there is no argument, no explanation of why he didn't do anything for an additional 6 months, which you have 30 days on the Tennessee Rules of Civil Procedure to file an answer. So another 6 months, he would have lost another motion for default within that time period. It doesn't make sense, and it does not show an abuse of discretion in the court denying the motion to alter or amend or set aside the judgment. It was a willful failure to file an answer. The motion was not supported by adequate information to give the court a reason to set aside the judgment. Just a conclusory statement that I was ill, even if you name specific illnesses that are severe, a heart attack, surgery. What about the date? How long were you under the inability to act? Such that the court could put that together with the timing of being served with the lawsuit. That would be the type of information that would be necessary. And so that was not before the court. So the trial court denied the motion. And based upon that, set the damages hearing. And at that hearing, there was testimony.
The court did originally award the damages, and then upon the motion of the defendant, granted a new hearing on damages. Is that right?
That is accurate.
Now, what evidence was introduced at the damages hearing, the second one? And what findings, if any, did the trial judge make to justify the award?
So the evidence that was submitted, first we had the testimony of Mr. Crutcher under oath. He testified of his injuries. He testified of the facts of how he became injured. He testified about how that affected his life, the surgery that he had. The expenses were entered by certified record from the medical facility where he was treated, as well as the medical records were certified and submitted to the court. And based upon that information, the court, in my view, entered a very descriptive analysis of the non-economic damages and the economic damages, specifically eliminating certain amounts of the medical expenses that the court did not deem to be, she should not award. And then, as far as the non-economic damages, she specifically laid out the factors of the injury, the time, his ability physically to be able to run and walk, and he was in good physical condition prior to the incident. And afterwards, he was walking on a walker. He still had bullets in his body that had to be removed. His inability to function sexually with his partners, and a long period of time of physical therapy, and remaining and having to do additional medical treatments over a sustained period of time. The court laid it all out in the order, so it doesn't.
Which order are you talking about?
In the opinion, the final judgment opinion after the damages hearing.
I'm looking at a final order awarding damages. Is that, it's a two-page opinion, or two-page order?
Yes, Your Honor.
Entered on January 25th, 2023?
Yes, Your Honor, and it's supplemented in the statement, the final statement of evidence that was submitted by the court.
The court submitted a statement of evidence as well?
It did, Your Honor. In this particular case, there was no court reporter at the damages hearing. And upon the notice of appeal, the appellant filed a statement of evidence, and there was an objection made by myself on behalf of my client that it did not fairly comport with what occurred in the trial court. And according to that, based upon the rules of civil procedure, the court then corrected and entered a statement of the evidence.
So the trial court prepared its own statement of the evidence?
Yes, Your Honor.
All right.
And in that,
I've not seen that.
But
so.
those findings, do you think that's in the record? The statement of the evidence?
the statement of evidence is in the record, Your Honor.
But to get back to Judge Stafford's observation, you mentioned what I understood to be the trial court made findings, but apparently they're not in the final order. And there's no transcript of the evidence incorporated therein. So the statement of the evidence typically doesn't include a trial court's findings. But are you saying this one does?
I believe it does, Your Honor. And it specifically outlines the evidence that was presented before the court and the basis for its award. Okay. It doesn't number paragraphs. If I were, as a trial attorney, preparing a findings of fact to submit to the court, a proposed findings of fact, I would lay it out in a numbered paragraphs and each factor that I wanted the court to award or grant. It doesn't do it in that way. It's in paragraph format.
All right, thank you.
But Your Honor, based upon everything that occurred in this situation.
But let me go back. You said that the trial court excluded some of the medical bills that your client presented. Will we find that in the statement of the evidence?
It does not say what was excluded. It says what she found was appropriate to award. And it was based upon what was the certified records and billing statements that were submitted. Right. Specifically, having been at the hearing, I can tell you that the court did not award things that were written off by the facility. In my view, that the case law is such that that may not have been according to the law. It's my understanding that the collateral source rule would allow a plaintiff to present evidence of damages even if they were written off, but the court saw fit to view that in a different light. So I mentioned that to say that the court had a basis for making its decision such that it should not be disturbed, and it's certainly not, the default judgment should definitely not be set aside because of there is no abuse of discretion. And I just think that this case.
Well, in this case, it's really not an abuse of discretion standard for a judgment for damages. It's a question of, does the evidence preponderate in favor or against the trial court's findings, and is the judgment supported by those findings and that evidence?
Yes, sir. I apologize. I was going back to the first issue. I kind of went back and forth with that. Sure. But essentially, yes, with regard to the damages in and of themselves, I do find that, and that the court made a satisfactory finding regarding the damages that were sustained. This is a personal injury case, and it does cite the statute TCA 29-39-101 regarding economic damages. And in the statement of the evidence that was presented, that's part of the record, does lay out specifically the issues of the medical care, the expenses, the services, and the mental health component regarding his inability socially to interact in society as he once had before he was shot. And those things support the decision that the court made. Thank you, Your Honor.
All right, thank you, sir. We'll hear rebuttal.
So, Your Honors, I just want to address some of the issues that were raised by counsel for the plaintiff and for the appellee. The plaintiff was shot 3 times, and as this is briefed and is listed in the record, Mr. Crutcher was shot 3 times at point-blank range in the VIP section of a nightclub. Now, he does go on, and he admits under oath and in his deposition that he received funds from the Victim Impact Fund. He was the victim of a crime, and we acknowledge that, and we're empathetic and sympathetic to his position. And I also understand, with a new judge taking over and inheriting cases as someone who's clerked for a chancellor, it can be overwhelming and it can be a daunting task. And I know no judge wants to rehear an issue this many years removed from an incident. However, we are saddling a gentleman with a $300,000 judgment and an award against him.
But in this case, the second judge, Judge Ingram, conducted a full evidentiary hearing on damages. It wasn't like there was some reconsideration of the prior judge's determination. That was washed aside and you started afresh and anew. Correct,
Your Honor. And in response to that, we would say we cannot graft the statement of facts that the court submitted into the final order that is the genesis of this appeal. We are specifically appealing the order and the judgment from January 25th, 2023, awarding the plaintiff damages. It may be true that in the statement of facts it makes some reference to what was and wasn't heard at the final hearing because there wasn't a transcript. However, that cannot be grafted and incorporated into the final order.
Well, a statement of the evidence is to be considered just as if it were a transcript of the evidence if the judge certifies it. And in this case, not only did the judge certify it, she wrote it.
Correct, Your Honor. And our position is that we are appealing the court's order and the specific judgment from January 25th, 2023. Again, under the Lugo case, it's not this court's role to speculate or assume anything. It can only review the judgment and orders of the court. So those findings, in fact, and conclusions of law that comply with Rule 5201, that's what gives this court the ability to review and correctly discern whether or not the applicable law was applied to the facts of this case.
And that's all I'm asking. That the statement of evidence does not do that?
Does not what, Your Honor, specifically? Does
not provide the information for which the court can review the judgment that the court arrived at as far as damages.
I do think it's instructive and it gives the court guidance, and I think the entire record of a whole should be considered by this panel of judges on appeal. Certainly so. But it does not comply with Rule 5201, where we specifically have an award, and the court has said, we're awarding this amount of damages based on these specific factors. This is how we arrived at this amount. The order could have done that, but you can't do that after the fact of the statement of evidence or through the statement of facts.
Well, I'm looking at the statement of evidence, and it provides what medical expenses were awarded. And then it simply says in paragraph 3, $300,000 in non-economic damages pursuant to TCA 2939-101, 2, awarded to Mr. Crutcher against Mr. Eiffel. So, your client was at this hearing, is that accurate?
Yes, Your Honor.
Your client participated in the hearing?
He was not allowed to participate.
He was not?
No, Your Honor. The issues limited at the hearing were solely as to the award of damages. And our client speaks through a...
let me read you from the statement of
Sure,
evidence.
go ahead.
Defendant Paul Eichel took the stand to testify during the damages hearing on January 18, 2023.
Yes, Your Honor.
Is that incorrect?
No, he was allowed to take the stand, but two things.
You just said he didn't participate.
Well, Your Honor, if I can explain, he speaks through, I'm not familiar with the type of machine it is where you have throat cancer. And so as soon as we started asking questions that verged anywhere outside of the damages, the court, they granted an objection and disallowed him to testify to anything outside the scope of the
I
damages.
mean, this was a damage hearing,
Damages
wasn't it?
hearing.
Right.
And consequently, you already had a default judgment entered against you,
Correct, Your Honor.
or against your client, I'm sorry.
Correct, Your Honor.
Okay.
And if I may move on, Your Honor, so specifically, the appellee mentions the fact that between the time he was served and in 2022, he had not taken part. That's because there's no mention of him in these pleadings. So he was living in a halfway house when he was initially served, and all subsequent certificates of service were sent there and forwarded to him. These are mentioning multiple other defendants. These are mentioning all the other named defendants and the motions for summary judgments and the exhaustive pleadings that occurred over that period of years.
All right, thank you, Mr. Gallagher, and thank you, Mr. Stover, for your arguments. We'll take this matter under advisement. Call the next case, please.
Westport Insurance Corporation et al. versus Howard Tate